I would now like to recognize a senior Democratic member of the committee, Mr. Miller, for his opening remarks.
Before us today is a very reckless and partisan bill to destroy workers' rights. Today's exercise is nothing more than a rush to protect one special interest to the detriment of all American workers. Introduced less than 48 hours ago, the bill before us today has not received a single legislative hearing, nor has the committee explored any focused way of the underlying issue that this bill purports to address. But I recognize that there may be reasons for the majority to ram this bill through with as little sunlight as possible. One reason is the rush is that the obvious beneficiary of this bill is in the middle of a trial, where the majority admits that the facts are in dispute. The bill would dramatically change the rules in favor mid-trial. Also, the rush is necessary because the level of scrutiny would expose the bill to nothing less than a license for CEOs to punish workers for exercising their rights. This bill presents American workers with a choice. You can have your rights at work, or you can have your job. You can't have both. This legislation is draconian. It's offensive to anyone who cares about workers' rights. It opens the giant hole in the National Labor Relations Act, and it makes it much easier to play American workers against each other in a race to the bottom, and it makes it even easier to ship jobs overseas. For more than 75 years, the National Labor Relations Act has provided Americans the right to band together in unions and to bargain for a better life. And the National Labor Relations Board has administered and enforced this law on behalf of workers and employers. Under the law, it is illegal to retaliate against a worker for exercising those rights that are given to him under the law. These rights include the right to strike, the right to form and join a union, or even simply sign a petition asking for a raise or for better safety equipment. But these rights are meaningless if no one has an effective remedy when they are violated. The bill before us today strips the law's only meaningful remedy when the companies eliminate or outsource work in violation of those workers' rights. The impact of this change would be wide-ranging. First, the bill makes it easier to ship jobs overseas. American workers would lose one of the rare tools they have to fight employers who send jobs to China, Mexico, or other foreign countries. With little consequence, CEOs could quite explicitly tell employees, tough luck, their jobs are moving overseas because they exercise their rights. To be clear, any company is free to locate work at any plant in any state at any time, but you don't get to do it in retaliation against employees who exercise their legal rights under the law. The law is crystal clear that it is illegal to do it for discriminatory reasons. It is illegal to take away work for some workers, union or non-unions, because they have exercised their rights. That's exactly what Boeing is alleged to have done, and that is why the NLRB has acted. Likewise, it's against the law to close a factory and to ship jobs to a foreign country, not just to another state, for discriminatory reasons. But let me repeat for the benefit of some members of the majority. It is illegal to ship jobs overseas if a corporation did it in violation of the workers' rights. This bill takes away American workers' ability to fight offshoring, outsourcing, and keep jobs in the United States. Instead, this bill amounts to an outsourcer's Bill of Rights. Second, the bill eviscerates workers' rights in a fundamental way by making runaway shops legal for all intents and purposes. The company that wants to bust a union can set up a separate alter ego down the street, subcontract its work there, and eventually close down the unionized work site. The only effective remedy for this kind of conduct is to order the employer to return the subcontracted work. The bill no longer allows for that remedy. This bill provides employers with a loophole for firing workers to try to organize a union. An employer can transfer work to the most pro-union employees or lay off the most pro-union employees. The bill would not allow the NLRB to have work restored or transferred back. The repercussions go on and on. This bill is bad news for America, it's bad news for its workers, and it's bad news for the middle class. It is being rushed to assist a Fortune 500 company in a case that hasn't even been decided yet. And it would pull the rug out from under some other American workers who are so audacious to think that they could get a fair day in court, free from interference by this Congress, to defend their jobs. They are fighting to save their jobs, their careers, and their futures. This bill puts a thumb on the scale against these workers. It's workers in Washington State today who are the victims of outsourcing will be the workers in South Carolina tomorrow. This bill strips all workers of an effective remedies for unlawful outsourcing. Let's be clear, the bill does not create a single job. It's about rolling back workers' rights enshrined in law for decades that have helped to create the middle class. And this bill is about making it easier for companies to ship American jobs to China, India with impunity. Today's vote is just another part of a well-orchestrated agenda to undermine programs and laws that make for strong middle classes possible. This agenda is doing its best to push our recovery into retreat, to squeeze the middle class, and to stall job growth. Instead of fearing Americans' workers and looking for new ways to walk all over them, this committee should be looking for ways to ensure that workers' rights are upheld in the workplace. I urge my members to vote against this serious reversal of Americans' rights in America today.
I would be happy to yield to the ranking member.
I would just say on this, the suggestion is on the other side that somehow there is an equivalency here because Boeing has created what was reported, I guess, as 2,100 jobs, and therefore everything's fine. All these jobs will be created in South Carolina, all the jobs will be created in Seattle. The fact of the matter is that the jobs in Seattle are temporary. They're temporary because Boeing needs some kind of surge capacity over the next couple of years to try to meet its contractual commitments, because the fact of the matter is that as we know, the international outsourcing plan kind of didn't work out. Not everything came together the way that the company had hoped that it would, as it spread the work around different parts of the globe and for other reasons. So those jobs are temporary. I suspect a number of them are also construction jobs because they're tearing out various facilities to create new ones for that surge. But they say in their own newsletter that the line will be used for up to 3 years. And when the second line in South Carolina is up and operating, the surge capacity in Everett will be phased out. Implementing the surge is another step forward in our production system. So there isn't an equivalency here. It also suggested that back pay is the deal. So you're laid off, you're put out of work because your job is taken away and moved somewhere else. You go and you try to get back pay. The employer fights you on back pay, and it goes on and on and on like this. In the mean process, I mean, this is very typical of what happens. People have been out of work or they get a low-paying job to try to hold things together. They can lose their house, they can lose their car, they can pull their kids out of the company. Then they get back pay. It's offset by the work. But they've already been losers. They've been losers because they lost the economic opportunity of the job that they had. To suggest that somehow this makes people whole, there's just not very much evidence that it makes people whole at all. And do they get back pay for what? For the rest of their life because the job went to South Carolina. And so it just isn't the case here that's what's taking place in this idea that there's some kind of equivalency and everything works out and everybody's happy. That's not what's going on. The other one is we're in here interfering in this case, as Mr. Holt pointed out. And you got the CEO going from legislative office to legislative office telling everybody, we're going to win this case. We're going to win this case. Maybe they mean they're going to win it in this committee. I don't know. But if they're so sure they're going to win the case, then let the process work. You talked about a year to file it. In that year time, they were in settlement discussions. They were in settlement discussions. That's what the NLRB usually does. And 80%, as we heard in the testimony the other day, more than 80% of the cases are settled out. Everybody's working in good faith. At the end of the day, that hasn't worked. You have on the public record pretty substantial evidence that this is retaliation for the strikes, and the NLRB, I would say, would be missing its mission if, in light of that evidence, and I guess what they went through in the settlements, they didn't file this case. But we don't know the outcome. We don't know what the remedy is going to be, and so there's a lot of loose talk on the other side about how this is all just fine because somebody got a job in Seattle temporarily.
Mr. Tierney, but I'll yield to Mr. Miller in the first instance.
Thank you. If I just might, this question that somehow this prevents businesses from exercising a judgment where they're going to make planes, how they're going to do this, let's just remind everybody here that the 787, the movable trailing edge is made in Australia, the wheel wells are in Japan, the tail fins are in Frederick, Washington. The fuselage is in Charleston, South Carolina right now. The leading edge is in Tulsa, Oklahoma. Chula Vista is making parts of the engines. The four fuselages in Wichita, Kansas. The fairing wing is Winnipeg, Canada. It goes on and on and on where they've made this decision. It's to such an extent that now the markets are questioning whether or not that was a wise decision. Can you bring it all back together? They're described in the news report as sort of they've become an erector set assembler of ports. And the question is when they get them all back, and of course what happened, some of these things didn't fit and they're now running back down that's fine. But they've made all of these business decisions so that you now have 70% of the work is nearly 50 partners and top-tier suppliers and 135 sites spanning 4 continents. Nobody interfered with that. None of that has been challenged. People might not like it, whatever you have, but nobody went to the NLRB and said, you can't make these business decisions. They made the most expansive business decisions around a single product, I think, that we've witnessed in history. And so, to extrapolate from this case to somehow this is now, you can never make these business decisions, they've been making them, as have companies all over the country, to locate, relocate, to expand, to change venues. It happens every day.
Mr. Miller, you're recognized.
Thank you, Mr. Chairman, and I appreciate the debate that has taken place on this legislation. I think it's important, but I also think it's absolutely fundamental. The question before this committee is whether or not we're going to rip away the rights of workers in the workplace and take away the remedy that they would have for those rights all across this nation. This legislation is much broader than Boeing. It's about a workplace in every state in the union and whether or not those workers will be fired or will have actions taken against them because they stood up and said, I would like to have a union. I'd like to have a safer workplace. I'd like to have shorter working hours, whatever it is. At that point, under this legislation, those jobs can be taken away. The facility can be moved to retaliate against those workers. The law of the land is you don't get to do that. It's not fair. And yet we know in campaigns to organize workplaces, that one of the #1 statements that is made to workers is, if you join the union, we're going to move the plant. If you join the union, we're going to move your job. If you join the union, you're going to lose your job because we're going to move the work somewhere else. That's a threat. With this legislation, it becomes a reality because it doesn't happen because it's against the law. A considered decision by the Congress of the United States that workers who stand up, workers who are trying to seek a better life for themselves, their co-workers, their community, ought to have some protection, and they ought not to lose their livelihood as a result of that. And that's the question that's in front of us for this committee, because this isn't just what happens to Boeing, whether they structure some kind of remedy if the decision goes against Boeing. This is about this Congress making a decision all across America. Workers will lose their rights when this becomes the law, and that's fundamental. You know, all of the reasons cited by Mr. Wilson in his promotion of South Carolina, all of those reasons are reasons that companies can move. They could go for better climate, a different society, approach, access to beaches, palmettos, whatever it is they want to go, they can go for, they can go. And I say that as somebody who has 2 sons that graduated from the University of South Carolina in the law schools. I mean, this isn't about that. This is about whether or not you can retaliate, whether or not you can look a worker in the face and say, you sign that union card, your work is gone, and no remedy exists for you. No remedy exists for you. Yes, I appreciate what's on the books. No real remedy exists for you. And we're going to do that now all across the country. And so we had better understand that we are now empowering those employers that take these actions or articulate these actions. They don't get to take them because of the law, but they articulate these actions against workers and workplaces all over this country. We sat in on a case out in my neck of the woods in Sacramento and Blue Diamond. The employee of the year, I think 3 out of 5 years, went to the employer and said, I'd like to have a union. He was fired. By the time we got back to reinstating him, and he was reinstated some 4 years later, he'd lost his house, his car, and the rest of it. This isn't about that there's a remedy there that makes workers whole when they're illegally retaliated against. And we have to understand that that's what this case is about. That's why this debate is going on. It is a fundamental difference on both sides of the aisle. But this legislation links up this Congress, this committee, with the campaign and the war, if you will, against workers' rights, whether they're public employees or private employees, all across the country. The citizens of the rest of the United States who didn't see themselves linked with Wisconsin or Ohio or Michigan or Florida, well, they're now linked if this legislation is successful. There's a statement of people who, by those of us who are fighting against those actions to be taken, it says, we are one. Well, this legislation makes that truth. We are now all one without rights at work when this becomes the law. We should vote against this. We should keep this from becoming the law of the United States of America, where workers ought to have rights. They have them today, and we should not take them away. I thank all of my colleagues for participating in this debate. Mr. Chairman, we will not have any amendments to this bill on the theory that you can't amend a bad bill.